Hello, law students and legal practitioners. Today, we will discuss the case of CCMC versus Quicklend, Inc., NPC case number CID 18-K-200 and decided by the National Privacy Commission in 2020. Let's begin. The doctrine of this case provides that the inadvertent disclosure of personal information resulting from operational lapses, such as sending a mass email using the to field instead of BCC, constitutes a personal data breach under the Data Privacy Act of 2012. Good faith, clerical error, or absence of malicious intent does not excuse a personal information controller from liability for unauthorized disclosure. Email addresses, names, and other identifiers which can reasonably ascertain the identity of a data subject constitute personal information. Disclosure of such information to unauthorized third parties without a lawful basis amounts to a confidentiality breach, falling within the ambit of a personal data breach under NPC Circular No. 1603. Personal information controllers are strictly bound by the 72-hour breach notification rule, requiring prompt notification to both the National Privacy Commission and affected data subjects upon knowledge of a personal data breach. Delay attributable to neglect, lack of internal protocols, or misunderstanding of the time frame violates the DPA and NPC issuances and reflects failure to implement adequate organizational and procedural safeguards. I will now share with you the facts of this case. Complainant CCMC received on the 10th October 2018 an email from Quicklend, Inc., a financing company, with the subject, Early Payment Reminder. The email was intended as a routine loan payment reminder but was sent as a mass email to 136 recipients, with all recipients' email addresses visible in the to field instead of the BCC field. CCMC noticed that among the recipients was her work manager, along with other acquaintances, thereby exposing her identity, email address, and the fact that she had a loan with Quicklend. Several addresses also contained additional identifying information such as middle names, employers, and even birth dates. On the same day, CCMC replied to the email asserting that Quicklend had breached the Data Privacy Act. The following day, an employee of Quicklend apologized and assured CCMC that the incident would not recur. CCMC subsequently filed a complaint before the National Privacy Commission on the 30th October 2018. Quicklend admitted that the incident was caused by human error, an employee mistakenly placing email addresses in the to field rather than BCC. It claimed that the disclosure was unintentional, apologized to affected clients, issued a reprimand to the employee involved, and later notified recipients of the incident. However, Quicklend notified the NPC only on the 5th of November 2018 and informed data subjects on the 7th of November 2018, several days after the occurrence and after having been alerted by CCMC. Here are the issues resolved by the National Privacy Commission. Issue 1. Whether personal information was involved in the incident. Yes, personal information was involved. Under Section 3(g) of the Data Privacy Act, personal information refers to any information from which the identity of an individual is apparent or can reasonably be ascertained. The email exposed CCMC's name, email address, and the fact of her loan obligation. Other recipients' entries even contained more identifying details such as employers and birth dates. These data points, whether individually or collectively, clearly constituted personal information. Issue 2. Whether the incident constituted a personal data breach. Yes, the incident constituted a personal data breach. NPC Circular No. 1603 defines a personal data breach as a breach of security leading to unauthorized disclosure or access to personal data, including confidentiality breaches. By disclosing her personal information to 135 other recipients without consent or lawful basis, Quicklend committed an unauthorized disclosure. The breach was a confidentiality breach, regardless of its accidental nature. The company's admission that the disclosure resulted from error confirmed the presence of a personal data breach. Issue 3. Whether good faith or clerical error absolves Quicklend of liability. No, good faith or clerical error does not absolve liability. The Data Privacy Act imposes strict obligations on personal information controllers to protect personal data through appropriate organizational and technical measures. The Commission emphasized that inadvertence or honest mistake does not excuse non-compliance. The incident highlighted Quicklend's lack of sufficient internal safeguards in breach response protocols, which the law requires to prevent exactly such disclosures. Issue 4. Whether Quicklend complied with the breach notification requirements. No, Quicklend failed to comply with the 72-hour notification rule. NPC Circular Number 1603 requires notification to the NPC and affected data subjects within 72 hours from knowledge of a breach. Despite being informed of the incident on the 10th October 2018, Quicklend notified the NPC only on the 5th of November 2018 and data subjects on the 7th of November 2018. The Commission ruled that the 72-hour period is continuous and not suspended by weekends or holidays, and no valid ground for delay was shown. That's all for today. Thank you for listening and happy learning. See you again for our next case discussions.